Is the Civil Society Reference Group, which is a coalition of over 200 community groups, CSOs, PBOs from across 25 counties, including Migori County. And we want to announce that yesterday, on 5th April, Csrg filed a case at the High Court challenging the legality of the aspect of privatization that has been taking place across the country. You know that the government has been selling public entities, public parastatals, including Sony Sugar, including Kenya Seed Company, and that's why as Csrg we went to court so that we can challenge this process. And we went to court through our advocate, Mr. Kevin O'Reilly, and what we were saying is that the transactions that are being done by government are illegal and they amount to a material breach of procedure because they have not gone through parliamentary ratification, stakeholder engagement, and public participation. You know, the Act for Privatisation, Section 12, Section 21, 22, and 23 requires that before such a process takes place, there must be public participation. We note that the public entities that are being sold are critical sectors of the economy, including the banking sector, the liquor and beverages sector, and the hospitality industry, which are quite lucrative for anyone to sell. And some of the earmarked business to be sold includes the Development Bank of Kenya, Kenya Wines Agency Limited, Kenya Safari Lodges, which includes Mombasa Beach Hotel, Ngulia Safari Lodge, Voi Safari Lodge. We also have Golf Hotel Limited, Sunset Hotel Limited, Mount Elgon Lodge Limited, Cabernet Hotel Limited, and Kenya Hotel Properties Limited. Of late, the government of Kenya has been on a mission to sell off public parastatals to be in keeping with the loan conditions given by IMF and World Bank. We note that the conditions set by IMF and World Bank mirror the structural adjustment programs of the early 1990s that saw the state sell all stakes in the public institutions, ceding the running of the economy to the private sector. A move that we term as an abdication of the social contract between the state and the people. Because when the government is supposed to provide us services, and then they are selling those institutions, then who can we hold to account? We can't hold account a private business. But the government, we being the taxpayers, we can hold them to account. That's why we are saying that the process must stop. And when we are going to court, we sought several relief, including asking the court to certify the case as urgent, which was granted by the court. We also sought the relief for the court to grant us orders of judicial review so that we can review whether the process or audit the process since it started, whether it has followed the law or not. So the courts gave us those orders, and Justice Jairus Ngaira, while giving the order, certified it as urgent because he noted that these are very much important institutions. He also gave all the orders for judicial review, but he declined to give us order of stay because he wanted the project to be stopped. He said that before such an order should be given, therefore the respondents, which is the cabinet, which we have sued the cabinet, and the Privatisation Commission, they must also be heard. So the judge ordered that the case be heard on 22nd. We are going to serve the two respondents, the cabinet and the Privatisation Commission of Kenya, and they have 7 days to respond. So by 22nd, the High Court will rule whether they are going to grant us orders to stop that process completely so that it can undergo through public participation.